Hello everyone, this is Dr. Sanskriti Srivastav and I'm presenting second lecture on sources of Indian Constitution. So here basically in this presentation we'll be studying about all the sources or all the countries from which various features of Indian Constitution are taken. Moving on to the next slide. Sources of the Indian Constitution. The Constitution of India is the backbone of democracy in our country. It is an umbrella of rights that gives the citizens an assurance of a free and fair society. The Constituent Assembly adopted the Constitution on 26th November 1949 and it came into effect on 26th of January 1950. 26th of January is celebrated as Republic Day of India. Now, starting with the most important source, that is the Government of India Act 1935. Government of India Act 1935 is the first and foremost a very important source of Indian Constitution. The Constitution of India 1950 was a byproduct of the legacy started by the Government of India Act 1935. Most importantly, the Act established the office of the Governor. All the executive powers and authority of the center was vested in the Governor. Federal legislature, the act suggested that the legislature will have two houses, i.e., the Council of States and a Federal Assembly. That means there will be a division of powers. Central government, or also referred as the union government, will always have a higher power or will always overpower the state government. And during the time of emergency or in president's rule time, union attains more power. So that is basically federal legislature. From the United Kingdom, following features we have taken from the Constitution of UK. These countries were developed before India, so we have taken lots of features from these countries. For example, some of these are parliamentary form of government. In such form of government, the country is governed by a cabinet of ministers led by the Prime Minister. The Prime Minister is the head of the government, whereas the President, the nominal head, is the head of the state. As all of us know that President has mere signatory power, whereas Prime Minister is the one handling the real business. Moving forward, the main feature of the parliamentary form of government is the availability of one or more opposition parties that exists to keep a check on the ruling party and its functioning. This is a very important feature because if opposition party will not be there, then there will be no watchdog on the actions of the ruling party. So there is always a need of a critic, a person who can find out the shortcomings in the work of the ruling government. So there is also the concept of opposition parties. Then comes the concept of rule of law. Rule of law also we have taken from the Constitution of United Kingdom. This basically states that a state is not governed either by the representatives or by the people, but only by the law of that country, which means that no one is above the law. Law is the king of kings. This is a very ancient concept that whatever is written in the law, for example, the Constitution of India, even Supreme Court cannot violate the Constitution of India. The concept of rule of law states that everyone is equal before the law, even the ones making it. And Article 14 of the Indian Constitution codifies the rule of law. The concept of rule of law basically is stated in the Article 14, which clearly mentions that everyone is equal in the eyes of law, be it a poor person, be it a minister, be it a doctor, a lawyer, whoever there is, no one. Law does not sees you with different eyes. Law does not take account of the status or of the kind of lifestyle that one has. Law takes account the rights, the moral obligations, the legal duties, and the offense committed or whatever the charges. So, law does not differentiate on the basis of the post, power, or authority that one is holding, and that is one of the strongest pillars of democracy in a country. Moving forward, now comes the US, the United States of America, and some of the features borrowed from the USA are fundamental rights. Fundamental rights, as all of us know, are the most important rights in the Constitution. A person cannot survive in a country without the help of fundamental rights. In our constitution, Article 12 to 32 of the Indian Constitution contains all the fundamental rights. It is also known as the most important part of the entire constitution. Fundamental rights are the basic human rights given to the citizens of the country to assure them an equal stance in society. The six fundamental rights are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. So these are the rights given to us by the constitution. Next comes the concept of judicial review. The provision of judicial review gives the judiciary an upper hand in interpreting the constitution. So basically, the judicial review power is there in Article 13 of the Indian Constitution, and basically it states that no one can pass or make a law or any order. Even court cannot pass a judgment which is violative of the fundamental rights of the citizens. So it is like a superpower in the hands of judicial system, which gives them the authority to check if there is any law or anything which is violative of fundamental rights. Then Supreme Court or High Courts can declare it null and void. The judiciary can thus nullify any order by the legislature or executive if that order is in conflict with the constitution of the country. So this is a very important right. Ireland. The main feature borrowed from the Irish constitution is the provision of the Directive Principles of State Policy, also known as DPSP. DPSP are listed in the Part 4th of the Indian Constitution, and it clearly states that it is the duty of the state to apply these principles in 4/7, the process of law making. Basically, this means that the directive principles of state policy are not enforceable in the court of law, but they act as the guiding principle. Government has to take into account all these principles so that while making laws for the citizens or while implementing laws for the citizens, government must adhere to these principles. Then comes Canada. From Canada, the provisions of a federation with a strong center are taken. Residuary powers of the center, appointment of state governors by the center, and the advisory jurisdiction of the Supreme Court. All these features have been borrowed from the Canadian Constitution. Article 248 of the Indian Constitution states that the Parliament has the sole power to make laws regarding any item not mentioned in the Union and State list respectively. Article 143 provides for an advisory jurisdiction for the Supreme Court. Under this provision, the President may seek opinion of the Supreme Court on public matters, and the Supreme Court may then further give its opinion after studying the case properly. France. The Indian preamble borrowed its ideals of liberty, equality, and fraternity from the French constitution. The Indian state came to be recognized as a Republic of India in the lineage of the Constitution of France. Australia. The Constitution of Australia lent us the provisions of freedom of trade and commerce within the country and between the states. The provisions of the same are laid down in the Articles 301 to 307 of the Indian Constitution. We also received the provisions of the concurrent list and the joint sitting of both the Houses of Parliament from Australia. Concurrent list is basically the list on which union as well as state government can make law, and in case there will be a conflict, union government's decision will be final. South Africa and Germany. While the Constitution of South Africa gave us the provisions of the procedure of amendment and the election of the Rajya Sabha members, the German Constitution gave us the provision of suspension of fundamental rights during emergency. These were the major sources of the Indian Constitution. As the father of our Constitution and the chairman of the drafting committee, Dr. B.R. Ambedkar said, as to the accusation that the draft constitution has reproduced a good part of the provisions of the Government of India Act 1935. I make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism, Nobody holds any patent rights in the fundamental ideals of a constitution. Indian constitution is also known as a bag of borrowings, but as Dr. B.R. Ambedkar also said, it involves no plagiarism. There is always inspiration. Thank you.